Okay, just 1 minute. So you're live.
Yeah. Thank you, Avni. Good morning, everybody. Welcome to the Sunday morning Manthan talk. Today we have the talk is on a very important subject, and we are honored that to give the talk we have Anjali Bharadwaj, who's been working on the right to information for more than 20 years. Anjali she's highly qualified. She has a postgraduate degree first from the Delhi School of Economics and from Oxford University. But since 2000, she has been the co-convener of the National Campaign for the People's Right to Information. And this is the campaign which played a very important role in having the legislation enacted in 2005. Since then, she continues to be active in this field, and she has written a number of reports on this on the RTI. She is also involved in other rights-based campaigns like the National Right to Food campaign. She will talk today about the RTI, which all of us have been familiar with for the past 15 years since it has been enacted. But we have also been familiar with the fact that all governments, including the previous government which enacted it, has been busy whittling it down, the importance of the Act, the powers of the Act, and this government has taken it further. More than that, while people have tried to use the RTI, many have suffered, many have given their lives. Anjali today will talk about why the right to information is so important and what we as citizens should be doing about it. Anjali, over to you, and we're very happy to have you with us this morning.
Thank you very much, Ram, and thank you everyone at Manthan for having me here today. It's a privilege. I'm going to talk about the right to information, like Ram said, and the RTI law was passed in 2005. It's been 16 years. It really gives a legal framework to citizens to access information from the government. Now, if we examine it in the larger context, the right to information as a right has actually existed since we gave the Constitution to ourselves. The Supreme Court of the country has, in several judgments, upheld the right to information to be a fundamental right flowing from Article 19(1) of the Constitution, which guarantees people the right to free speech and expression. Now, basically, what the court has repeatedly said for many decades is that without information, people cannot really formulate their thoughts, and therefore there is no possibility of freely speaking or expressing themselves without having information. And in a democracy where governments are supposed to work on behalf of citizens, there is really no information or very little information that should be withheld from citizens. So the information is being held by governments on behalf of people, of citizens, and therefore it is the obligation of the government to share information with citizens if the citizens want that information. And in fact, the right to information law, which was passed in the year 2005, came as a result of a very long and vibrant movement, people's movement, where people realized how important it was for them to have access to government records, to be able to hold the government accountable and get what is rightfully theirs. People across the country demanded the right to information law, whether it was in the rural areas, in the remote villages of Rajasthan, or it was in the slum bastis of Delhi, in other states. People were demanding the right to information law for many, many years before the RTI law got passed in 2005. In fact, before the national law came into being, there were 9 states that passed right to information legislations in the country. The Delhi, Rajasthan, Tamil Nadu, Karnataka, there were 9 states that passed these laws. People started using these legislations, which were not very perfect, to access information, and realized how powerful information could be for them to hold the government accountable. I work with a group called Satark Nagrik Sangathan, SNS. We work with in the slum bastis in Delhi. I remember when the Delhi Right to Information law got passed in 2001, in the slum settlements, in our meetings, we told people that there is this fantastic law and you must use it. I still remember one of the women stood up in the meeting and she said, "Ration to milta nahi hai, सूचना का क्या करेंगे?" Basically meaning that we don't even get our subsidized food grains from the government. What are we going to do with information? And we realized that people are not interested in information for the sake of information. They want information if it can help them access what is rightfully theirs, their entitlements and their basic rights, but which are denied to them because of corruption or wrongdoing. So we asked people, we said, why do you not get your rations? Have you tried talking to someone in the government? What has been your experience? Why don't you get your rations? And women in these meetings told us that the government officials and the shopkeepers tell them that the government does not send their share of rations to the ration shop. And therefore, they said that we are told that if your ration is not reaching the shops, then we cannot give you your share of rations. Now, we told people about the right to information, and 2 women came forward, Sunita Devi and Zarina Begum. And both of them said that we will file right to information applications. And they were amongst the first few people to use the right to information law in Delhi to ask for the stock registers and the sale registers of their ration shops. And when they asked for this information, they received records. The stock registers of the shops in their area showed how ration was reaching the shops every month. So the stock register had entries every single month showing that ration was in fact reaching the shops. The sale registers that they got were a complete work of fiction. They had names of people who had died long ago, people who did not live in those slums ever, who were supposedly given the ration to. And there were these thumb impressions that were running down the entire sale register. And people looked at that information and were absolutely livid. So several complaints were filed with the food department where people said that our rations have been pilfered. And people told us that we always thought that there was corruption, but for the first time, we have proof of corruption in our hands today. So a public hearing was organized where more than 500 families got together. Senior government officials were invited. They came for the public hearing. Shopkeepers, the ration shopkeepers were invited. And of course, the media also came to cover the public hearing. In the hearing, people read out the records that they had accessed using the RTI law. And they asked the government officials why this was allowed to happen, why no action had been taken for so many years when they were not getting their subsidized food grains. The result of this public hearing essentially was that at least 3 sorts of things happened. One, people who were responsible in the food department, there were disciplinary proceedings that were initiated against them. Second, several ration shops which were found to be indulging in corruption, they were shut down, their licenses were withdrawn. But most importantly, everyone started getting their full share of rations. And that really established for the people the importance of information. And they realized this connect, that without the right to information, they would not be able to access their other rights and entitlements, and how important information was for them to be able to get their rations, their pensions, their other rights that accrue to them. It is in people like Zarina Begum, like Sunita Devi, in the slum settlements, people in rural areas, who all realized how important a strong legal framework, a law would be for them to access information. And all of these people and lakhs of people from different socioeconomic backgrounds got together and demanded the right to information law, which was finally passed in the year 2005. Now, the law is considered one of the most progressive legislations globally. So there is a global index which ranks all the laws, the right to information laws, and these laws, when these laws are stacked up, the Indian right to information law is pretty much at the top. One of the reasons, of course, is that it drew on the experience of people who tried to access information but were denied information and knew what a legal framework should look like. So the law is very progressive. It lays down the time frame within which people should be able to access information in about 30 days. It talks about what is the information that can be accessed and very stringently defines the exemptions. So things like unwarranted invasion of privacy of someone, that sort of information cannot be accessed. Information that would clearly have a bearing on, a negative bearing on the integrity of the country, security of the country, that sort of information cannot be obtained under the right to information law. But apart from that, all information that is held by the government can be accessed by citizens today in the country. And the law is very clear. It says that even if certain categories of information are exempt, as long as there is larger public interest in accessing information, people can be given that information, even if it is exempt. So the law is considered one of the most progressive laws in the world. But I think what is even more significant is how vibrantly the law has been owned by the people of the country and how it is being used, how vibrantly it's being used. We've been involved in several assessments of the implementation of the right to information law. What data shows is that anywhere between 40 to 60 lakh RTI applications are filed every year in India. So 4 to 6 million RTI applications are filed every year in our country. This is probably the highest anywhere in the world. And a very important aspect of the use of the law is that it's not just used by journalists like in many countries, or by lawyers, or by very educated people. It's used by the common people of the country, many people who are even unlettered, but who understand the significance of information. A large number of RTI applications are filed by the poorest and the most marginalized communities in the country, who have understood the power of information and how it empowers them to interact meaningfully with government departments and officials and hold them accountable. The law has been used not just to access information about basic rights, but it has also been used to hold the highest offices to account. So we've had people asking for information about the assets and liabilities of Supreme Court and High Court judges, where people feel that there is judicial corruption, and they understand that the best way to establish judicial corruption is to see whether judges have any any assets and which are disproportionate to their known sources of income. So people have filed RTI applications to ask for the assets and liabilities of judges of the higher judiciary. People have also asked for information about elected representatives, about their functioning. We work in slum settlements, where I remember in 2006, we hold meetings every week in slum settlements and talk about people's rights, about how to use the right to information and other rights. And many people come for these meetings. They are very well attended. But in 2006, there was a set of elections in Delhi, and we realized that suddenly nobody was coming for the meeting. So we went to people's homes and we tried to ask them why they were not coming for the meetings. And they said that they had been told that their slums are going to be demolished, that they could not therefore leave their children, their belongings, and come for the meetings, which was absolutely understandable. After the elections, people again started coming for the meetings. The following year, there were Delhi state elections to the Legislative Assembly. And the same pattern repeated itself, where people again stopped coming for meetings. And when we asked them, we were told that their slums are going to be demolished. So this time, we helped people file right to information applications, asking for the list of slums that were supposed to be demolished in Delhi. And when that list was obtained, not a single basti that we work in was listed there. So we went and we pasted that list outside every slum settlement, and people came for the meetings, and they came and told us, they said, we tried to find out, and we've realized that before elections, the candidates of various political parties spread these rumors and misinformation that slums are going to be demolished. And we are told that only if we vote for them, will our slums be safe. So there was a certain anger where people said that instead of giving us information, instead of keeping us informed, there is this active misinformation campaign that takes place. And they said that we want to know how our netas are performing and what they are doing once we vote them into power. So there was a very strong felt need to access information about the working of elected representatives between elections so that they could be held accountable. RTI applications were again filed by people living in slum settlements, people living in several higher income colonies also, who said, even we don't know what our elected representatives are supposed to do and what they actually do in the 5 years that they are in power. The information that was obtained was around 3 or 4 things. One was, the performance of elected representatives in the House. So in the Legislative Assembly or Parliament, and people asked how often, so about the attendance records of the elected representatives in the Legislative Assembly and Parliament. People also asked about the questions that they raised. Did they raise any questions of public interest? Another thing that people were very interested in asking for information was about how much local area development funds each elected representative gets and how they're using those funds. So RTI applications were filed asking for information about each elected representative in Delhi, MLAs, MPs, how they were spending their local area development funds. In the 5 years. And of course, elected representatives are supposed to monitor the working of the executive. So how were these people attending the vigilance committees, what their attendance was like in those meetings. So all of this information was sought. And of course, it was not easy to obtain this information under the RTI law, but information was obtained. And when information came out, people engaged with the information and found it extremely useful. We held information camps in different parts of Delhi. And I remember at one of the information camps where we put out information in Begumpur in Delhi, in the Malviya Nagar constituency. There is a huge water scarcity. People find it very difficult to access water. Water supply is erratic. It only comes at night after around midnight, and people have to queue up for hours to get water to drink. And they said that we keep going to the MLA, we keep going to the government asking for piped water supply, but we are told there are no funds. So when this information was put out in the information camp in Begumpur, people looked at how the MLA had spent his local area development funds. And they realized that the MLA had spent more than 70% of his funds in constructing fountains in parks. Now, these fountains, when a social audit was done, we realized that these fountains had been lying dry because there was really no water in that area, and they were being used as garbage dumps. People living around the fountains said that we had never asked for these to be installed. We don't want these are eyesores. And yet money had been spent, which was meant for the most pressing development needs of people of the constituency, had been spent on constructing these fountains. So when people saw this information, they said that, we don't have water to drink. And this is how our elected representative is spending his local area development funds. And more than 100 women from the Bastis got together, went up to the office of the MLA, the local MLA, and confronted him with information and said that every time we come to you asking for water pipes to be laid in our slums, you tell us that you don't have funds, and you promise us that when you have the funds, you will provide us water supply. Now, here is the information. It shows that you've been spending 70% of your funds on fountains. Why should we vote for you? And that became so powerful. The member of Legislative Assembly, the MLA, immediately sanctioned water pipes to be laid in these slum settlements, and people started getting water supply in their homes. And people have, like this, realized how not just the executive, but the judiciary and the legislature can also be held accountable using the RTI law. The law has, of course, also been used by people to query the actions and the claims made by various elected representatives. So, for example, when the Prime Minister in his affidavit claimed that he had done his undergraduation from Delhi University and post-graduation from Gujarat University, there were people who filed RTI applications asking for the records, the results of those years from the respective universities. It's another matter that the Delhi University said that who passed out from the university is a matter which would cause unwarranted invasion of privacy of students, and therefore denied information. But this information has been sought. And the interesting thing, of course, is that for all other years, that information is available because the convocation ceremony is a public ceremony. But for that year, information is being withheld. The matter is in the Delhi High Court. But people are pursuing, people who are interested, who want to verify, who want to hold those in power accountable, keep using the RTI law to access information. The PM Cares Fund that was set up during the COVID pandemic to provide relief to people, and a lot of money, thousands of crores, nearly 10,000 crore rupees have been accumulated in that fund. People have been filing RTI applications to access who are the donors of these funds and where these funds are being allocated and utilized. Now, this is extremely important because we know one thing that we have learned from experience in our country is that unless people are informed, unless they know where the money is coming from, how much money is there and where it is going, there is very little likelihood of money reaching the real beneficiaries. And there is a huge chance of corruption prospering behind a veil of secrecy. So people are using the right to information law to access this information. Again, unfortunately, with the PM CARES fund, the government has taken the plea that it's not a public authority, PM CARES, and is therefore not sharing information, but the matter is again being agitated. Similarly, with the electoral bond scheme, essentially opens the floodgates for large, unlimited amounts of funding, including from foreign sources, to political parties in a completely anonymous way, because the electoral bond scheme says that anyone who funds political parties through the electoral bonds, the source of income, who is giving that money, will not be disclosed to citizens, which is a huge problem because, in a democracy, if we are expected to vote, and a lot of people in our country vote for parties, they don't really vote for candidates, it's very important for people to know which party is getting funded from where, because finally parties will work for those who fund them, and therefore it's very important for people to know who the party that they are going to vote for is funded by, because they would then know who they are going to be serving the interests of in a very large way. Unfortunately, this information on electoral bonds has not been forthcoming. The way the scheme is formulated, it's designed for secrecy, and people have accessed information about or tried to access information about these bonds. And what has been found is that the RBI, the Election Commission of India, all these accountability institutions actually dissuaded the government from bringing in the electoral bond scheme, where they said that if the scheme is brought in, electoral bonds are brought in the manner that they have, they will lead to black marketing, to money laundering, black money being generated, because they will result in shell companies coming into existence, and it will really destabilize democracy. And yet we saw that the government completely ignored what these institutions said and went ahead with electoral bonds. The material that has been brought out using the RTI law is being used in several cases that have been filed in the Supreme Court challenging the electoral bond scheme. Again, the RTI law has been used to expose big ticket corruption, corruption in scandals, scams like the Adarsh scam, the Vyapam scam. In fact, there is hardly any scam that has been unearthed since 2005 where the right to information law has not played a significant role. The law has been used by different campaigns, different social movements, people's movements in the country to access information. Whether it is the environmental movement, it has used information using the accessed under the RTI law, or it is the movement for the right to education, the right to food. Different movements, different campaigns have used the law very, very effectively to further their cause and to strengthen their struggles. So the law has been used to achieve a lot in the last 16 years. It has really empowered the people of the country. It's perhaps been one of the most empowering legislations to be passed in independent India. And what we have seen the law do is to shift the balance of power from those who govern to citizens, to those who are governed. And it's something that people have recognized and people are very fiercely protective about. The law, like I said, has been used to show truth to power. And we often say that the right to information law has made potentially each one of us, the 1.4 billion Indians, a whistleblower, because earlier whistleblowing could only be done by people who could access government records, and there were often people within the government. But today, with the right to information law, each one of us has the power to access government records and blow the whistle on corruption and wrongdoing. So naturally, as Ram mentioned as well, this is not something which is particularly, welcome by those in power, because after all, information is power, and sharing information tantamounts to sharing power. And those who have been used to being in power without being held accountable do not particularly like this law, and there has been a constant backlash ever since the law was passed 16 years ago. We've had consistent attacks on people who use the right to information law. These attacks come in the form of threats. People are regularly threatened when they file for information. If it exposes corruption, it exposes wrongdoing, they are told that they should not file RTI applications. We know of so many women in the bastis who asked for the records of their MLAs and councillors and MPs who were threatened, who were told that you will not be allowed to live in Delhi, your ration cards will be cancelled. Why are you asking for this information? Your children go to school, you're vulnerable. Why are you trying to take on such powerful people? So there are all these threats that people get when they try to access information. There are many who are attacked physically, and nearly 90 people have been killed for simply asking for information and exposing corruption and wrongdoing. The lasted attacks in Rajasthan, in Gujarat, Amraram, who was tortured, Nandi Singh in Assam, who was killed, who was hacked to death for exposing corruption in the public distribution system using the Right to Information Act. In Manrega, people have used the Right to Information law to expose corruption, and they've had to pay with their lives. So there is a huge issue of the safety of those who dare to show truth to power, because there are powerful vested interests who don't want this to happen. And as a result, those who access this information and then use it to file complaints are very, very exposed to these kind of threats and attacks. It's very unfortunate, but when the current government came to power in 2014, there was a lot of talk of Bhashtachar Mukt Bharat, of a corruption-free India, where people were promised by the BJP that if they came to power, there would be a strong anti-corruption framework, there would be greater transparency and accountability. And what one had hoped was that the right to information law would be strengthened during this regime. Unfortunately, what we have seen is a very, very strong attack on the right to information framework in the last 8 years. One of the first things which really talks of the mindset of the government is how the act of questioning is constantly attacked, because the right to information is really the right to question, the right to say, to ask the government what it is doing, ask for records, and to hold the government accountable. There was a case of extrajudicial killings near Bhopal in Madhya Pradesh, and one of the union cabinet ministers went on to say that when people asked for information about those extrajudicial killings, he went on to say that there is a big problem that has taken birth in this country, and that is the culture of questioning. And he said that people should just trust the government that they vote in. Why should they keep asking questions? The government should be allowed to do its work. People should trust the government to do the right thing. And that mindset is something that we see is all pervasive today, where anyone who questions, anyone who seeks information, who seeks accountability, anyone who dissents, those who use the right to information are really seen as doing an anti-national act. So people are called anti-nationals. They are told that they don't have faith in the government, they don't trust the government. Draconian laws are used, and people are being implicated in different kinds of cases simply for asking for information and daring to question. So that is the environment which we are operating in, and the right to information law and the attacks on the law have to be seen in that larger context. And like Ram said, no government has been particularly interested in sharing information, because they realize that it empowers citizens, it results in their power getting eroded, those who have been typically used to being in power. But the kind of attack that we have seen in the last 8 years is unprecedented. The right to information law itself has been weakened. There was an amendment that was brought into the RTI law. The first time that the RTI law has been amended, it was the autonomy of the information commissions, which are responsible for making sure that people have information, was undermined. So under the RTI law, each state has an information commission. There, at the central level also, there is an information commission, the Central Information Commission. And the information commissions are supposed to be independent bodies. They are supposed to work without fear or favor, and supposed to work to ensure that people get information. And for that purpose, they have been given many powers, including the power to penalize public information officers if they don't provide information to citizens. So their work will only be as good and as effective as the independence that they are given. The 2005 law ensured that the information commissions and the commissioners who are in the commission could function independently. To do that, the law basically made sure that the salaries of information commissioners are not fixed by the government directly. So the salaries of information commissioners in the Central Information Commission were pegged at the same level as those of the Supreme Court judges. So, it was not decided by the central government. The salaries were decided in accordance with the Supreme Court, with what the election commissioners and the Supreme Court judges were getting. Similarly, the tenure of information commissioners was fixed at 5 years, subject to their getting retired at 65. So any time that an information commissioner was appointed, they knew that they would serve for a period of 5 years. This was all done to insulate information commissioners from any interference and any kind of pressure from the executive. Unfortunately, the amendment bill, and finally which became a law, which was brought in by the government, said it empowers the central government to decide the tenure and salaries and pensions of all information commissioners in the country, both at the center and at the state level. So essentially, the law as it stands today, along with the rules, says that the central government will decide the tenure of each information commissioner, and the central government will decide on a case-by-case basis the salaries of information commissioners and the pensions that each of them receives. Now, this is highly problematic, because what this means is that if an information commissioner knows that their pension is going to be decided, post-retirement pension is going to be decided by the central government, they would always be worried while they are giving any direction for disclosure of information, that if they give any directions which the central government does not approve of, then their terms of service would get adversely impacted. Now, this is a direct attack on the autonomy of information commissions. Not only that, we've seen that one trend which had started in the previous government, in the UPA government itself, has further strengthened in this regime, which is not making timely appointments to information commissions. So information commissions are supposed to have a chief information commissioner and up to 10 information commissioners. And these commissioners are supposed to adjudicate on all the appeals and complaints that come to them regarding denial of information and violation of the RTI law. If information commissioners are not there in the commissions, or their numbers are too few, then these complaints and appeals keep piling up, and there are huge backlogs that get accumulated, and people have to wait for a long time to get their hearing at the commission and get their information. So what the governments typically have been doing is not making appointments to information commissions. The current government has, of course, taken this to great lengths. The Central Information Commission, if we look at the appointments made to the CIC, we see that in the last 7.5-8 years that the BJP government has been in power, not a single information commissioner has been appointed to the CIC without people having to approach courts. So when information commissioners retire, and these are all routine retirements, government knows when they are going to retire, appointments are not made on time. In fact, appointments to the CIC have not been made at all till citizens have approached the Supreme Court and the court has pulled up the government and asked the government to make these appointments. So each time an information commissioner has retired, people have had to approach the courts. Unfortunately, the same pattern is being followed at the state level as well. We create report cards of information commissions in the country, their functioning. And what the report cards have shown is that there are several information commissions which are working without adequate number of commissioners. 3 information commissions, Jharkhand, Tripura, and Meghalaya, were found to be working without any information commission. So basically, they were defunct, they were not working. And which essentially means that if I want information about the working of the government in Jharkhand, Tripura, or Meghalaya, and I'm denied that information, there is no commissioner that in the Information Commission. So I can't really approach the Information Commission and expect that I will be given justice and I will be given information. So it is really a denial and a violation of people's fundamental right to information in these states and in other places where commissioners are not being appointed in a timely manner. The backlog in different commissions put together is more than 2.5 lakh cases. So appeals and complaints are pending in various commissions, and which really results in people having to wait for long periods of time to get information. Now, this effectively renders the law useless for many people. So you can imagine that an old widow who is waiting for her pension is not getting her pension and asks for information. If she's denied that information and she goes to the Information Commission, if the case doesn't come up for hearing for 2 years, 5 years, 6 years, that information is useless for her because it's resulting in a denial of her basic right every single day, and she would find it difficult to survive. In Odisha, for example, the waiting period to get a hearing in the commission is about 7 years. So this makes a mockery of people's right to information. The other problem, of course, is that governments appoint their own acolytes, their own people who are loyal to government, as information commissioners. We've seen how a very large percentage of information commissioners in the country are ex-bureaucrats, are IS officers who have served in the government and have through their lives, many of them have worked to not share information. One of the chief information commissioners of the CIC was an ex-IB director. So, had spent much of his life keeping documents and records secret, and then was made the information commissioner of the country, the Central Information Commissioner chief. Also, the manner in which appointments are made is not transparent. And this is something that the Supreme Court has also issued directions on. Even recently, when on the directions of the Supreme Court, the central government made appointments to the CIC, the Central Information Commission, one of the commissioners who was appointed had not even applied for the post when the post was advertised. And in the words of the leader of opposition who gave a dissenting note, he was sky-dropped, and without giving any reasons, any rationale. So this kind of arbitrariness in appointment of information commissions really erodes people's right to information. All of these are causing a great deal of setback to people when they try and access their right to information in the country, and have emerged increasingly as challenges to the right to information regime. But one thing that I want to share is that the enthusiasm of people to access information has not waned. In fact, we see how even during the pandemic, people kept pushing and asking for information, and also the realization of how important information is for their basic survival came to the fore. We saw how people were struggling to get oxygen, to get hospital beds, essential drugs during the pandemic. And people were demanding information in the public domain. In fact, Section 4 of the Right to Information law says that people should not have to essentially come forward to ask for information. The government, it places an obligation on the government to proactively provide information which is in public interest to citizens. So people during the pandemic have demanded that the public health system information should be proactively displayed. In fact, the Supreme Court also said that information about oxygen supply and other important information should be put in the public domain, so that so that citizens have easy access to that information and don't have to run around to get help for their family and during the pandemic. Again, the kind of laws that we have seen getting passed recently in Parliament, which many people have been unhappy with, whether it's the farm laws, it is other legislations that have been pushed through without adequate debate and consultation in Parliament. People have filed RTI applications to seek information about those laws. So, for example, during the farmers' protest, one of the things that the government consistently said was that the farmers were being unreasonable and were opposing these laws unreasonably because extensive consultations had been held with stakeholders and farmers and experts before the laws were passed. An RTI application was filed, in fact, many were filed, asking for the consultations, the records of consultations that were held before the passage of the farm laws. And the response to the RTI applications clearly showed that the key stakeholders had not been consulted. There were no records of consultations that were held. And this was information that was also finally used in the court of law while challenging the passage of the farm laws. So in the current scenario, where we see that many institutions in the country, including the Parliament, are being subverted, they are being undermined, it is very, very important for people to keep asking for transparency, to keep asking for information. So the point that Ram asked me to talk about, that what can we all do? I think it's extremely important for us to be aware of the kind of threat that there is to the right to information and transparency regime in the country today. And this, in some senses, is really in consonance with the kind of attack on institutions, on democratic institutions and frameworks that we are seeing in the country. And if we want a vibrant democracy, if we want a government that is accountable to the people of the country, we need to keep making sure that the RTI law is protected. We need to keep making sure that we keep filing RTI applications, that we use the law as much and as vibrantly as possible, and we come together to ensure that the law is not tampered with and is not diluted in any way at all. I'll stop here and happy to take any questions or the discussion forward. Thanks.
Thank you. Thank you, Anjali, for that wonderful talk. I always knew that the RTI is a powerful tool of democracy and building institutions. But I think today you have given a perspective of how it is working and how it is being diluted. And that doesn't give a very comforting thought. But considering that the law is only about 16 years old, do you think that this is normal? That in other countries it took as much time where RTI or some act like that was implemented? Or is India going through a special process of dilution?
Yes. So I think that that's something that we all sort of are worried about, the dilution that we are seeing, the backlash in a sense. And you're absolutely right, Vikram, that some of it is quite expected because we are a country which adopted the constitution, decided to function as a democracy, but functioned in a fairly top-down format where those who were in power were not questioned regularly. But and what this law gives is really that tool for citizens to be empowered, for citizens to question. So often when we've spoken to government officials, and it's not just in this government, even in the previous government, they have expressed a kind of, dismay and helplessness, where they've said that, we've been used to functioning without people coming and constantly asking us questions. And, we find it so difficult to adjust to the fact that any person now from the street can come and question us and ask us to share information that we otherwise used to hold so close to us. So this is a new phenomenon in many ways for the country, for the administration, for the kind of governance that we saw earlier. It's a huge departure from there. But I still have to say that what we are currently witnessing is a very, very strong attack on the basic framework of transparency and right to information in the country. And the reason I say it is that it's coming at many levels. It's coming right from the top, where the message that is being given out is that to be a good citizen, you should focus on your duties, not on your rights, that you should be trusting, you should not question the government, asking questions, dissenting, being critical is anti-national, it's not a good thing to do. And then kind of filtering down to tinkering with the law, then to sort of, not make and making sure that institutions that are supposed to give information to people are not functioning properly. So we are seeing an attack at very many levels. There are attacks by way of acts of omission, by not appointing people, and also by way of commission, by actively diluting the law as it stands and dissuading people who try to access information. So yes, there is an unprecedented attack which we should be worried about, which I do not consider normal, Vikram.
Yeah, but then I think here we even have to talk on the role of the judiciary, that maybe they can take up these cases, even if not on priority, at least they can take up these cases on a routine basis. But looks like they're deliberately delaying these cases. So why is the judiciary not subject to RTI?
So let me clarify here that under the RTI law, all three, the executive, the judiciary, and the legislature are covered. And your question is very insightful, because many times we are very conscious of the fact that the judiciary, which was very active in saying that we have the right to information, has suddenly, we see, not been very proactive about saying that the right to information should be upheld in many places. So what we are seeing is that ever since the law was passed in 2005 and people started using the law to access information about the judiciary, there has been a kind of attempt by the judiciary to not share information. Because like I said, nobody really likes to share power and be accountable. So when people have asked about the assets and liabilities of judges, for example, it was something that was finally examined by a constitution bench, because the judiciary said, why should we give this information? And the approach of the judiciary has undergone, unfortunately, a change since the 2005 law has come about. Of course, there have been some good judgments, like the one about the appointment of information commissions in different states and at the center, but there have been many regressive judgments, unfortunately, that we have seen coming from the judiciary. For example, how does one interpret the privacy clause? That is something that the judiciary went on to say that the salaries, emoluments, the transfers of government officials does not have information about that does not have to be provided under the RTI Act. Now, those are very concerning and regressive judgments that have come. And there are many, again, issues on which transparency should have been ensured, like the electoral bonds case. It has been languishing in the Supreme Court for many years now. And despite the Chief Justice of India saying that electoral bonds and the lack of transparency is posing a huge threat to our electoral democracy, the case has not been settled. There is no direction that has come from the court, and we are still waiting. So the judiciary has unfortunately not been playing the kind of role that we needed it to play to ensure that people's right to information is protected.
Thank you, Anjali. That's really a fascinating talk, and your responses to the questions have also been detailed. There are quite a few questions on how-to questions. We can keep them at the end if you can share your experience. Specific questions, there's one from Sri Kumar, who I didn't know about this. He said, can you please cover the effectiveness of the proactive disclosure feature of the RTI Act? Where has it worked and why? I didn't know that there was a proactive clause as well. So if you could briefly tell us about that and whether it has worked.
Sure. No, that's a very important issue. I touched upon it, but I'm very happy to talk in some more detail about it. Section 4 of the Right to Information Act essentially puts an obligation on government departments, on public authorities to put out information on their own proactively without citizens having to file an RTI application. And according to many of us, who have been involved in the right to information movement and using it, we believe that it is one of the most significant aspects of the law, because in a country like ours, where 90% of the workforce is in the unorganized sector, you can't really expect people to spare a full day to go and file an RTI application. Then if they don't get information, go and file an appeal and then appear for a hearing and then, follow the entire process through. So the most powerful way by which governments can be transparent is if they put out information in the public domain on their own. Unfortunately, this provision is followed more in the breach. We've seen that this important provision is not being implemented properly. It's something that the National Campaign for People's Right to Information, different campaigns in states have regularly been taking up. But if one may call it, one of the loopholes in the law is that it says that a penalty will only be imposed on a public information officer for violation of the law. Now, there is no public information officer who's made accountable for Section 4 proactive disclosures. So that is being exploited by public authorities to not put out information properly, because the system of incentives and disincentives in the law, in a sense, which is really the penalty clauses, does not get invoked easily in this case. Now, we have been telling information commissioners that they should not hesitate to take action against the heads of the Department of Public Authorities if Section 4 disclosures are not made, because the way the governance structures are there, if a public authority is asked to do something, it's understood that it's the head of the Department of the Public Authority that is accountable. So we have been pushing information commissioners to take the view that if Section 4 disclosures are not made by public authorities, then it's actually the heads of the department who should be held accountable. And under various judgments of the Supreme Court, like the Sakiri Vasu judgment and so on, information commissioners can actually penalize the heads of the department as well. And that will send out a signal that this kind of violation will not be tolerated. We have unfortunately not seen that happen. And as a result, public authorities do not comply with Section 4 of the law with great impunity. They go ahead and not comply with the law, Section 4. And that is really a problem. Where Section 4 disclosures have happened, we've seen how powerful they can be. For example, I talked about the local area development funds of elected representatives. In the Central Information Commission, many women took this matter to court and to the commission and said that when we try and access information about how our elected representatives are spending their funds at their disposal, we are threatened and we are attacked. So why should this information about the spending of public funds be put on boards in the public domain? And as a result of that complaint, the Central Information Commission said that boards will be put up in every constituency and every ward of Delhi in local language, in Hindi, at public places, and it will display the projects that are undertaken using those funds. Now, people use that information regularly to hold their elected representatives accountable. Similarly, there are websites like in Rajasthan, in several other places, there are websites that have been started, portals that have been started by the government through pressure and collaboration with civil society in many cases to put out information in the public domain. And that is very powerful as well. So this needs to be done and needs to be done very, very strongly so that the right to information can be really meaningful for people. And Section 4 of the law is very progressive. It says that information should be put out in a way that is most accessible to people. So the government can't just get away by saying we put it on the website in English in a technical language. The government is supposed to put it out in a manner where people are able to access it. So in a country where most people don't have access to the internet, it has to be put out through wall paintings or through boards that are put up in public places. It can't just be put out in English. It has to be put in the local language so people can understand it. It can't be technical. It has to be in a manner which is understood by everyone. So it's a very powerful provision which needs to be followed.
There's another question. One particular viewer has asked variants of, you know where this question is coming from. Let me ask it. One, what is the experience in other democratic countries? Is there a right of information in communist countries? And third, what has been the experience in Kerala? So you can see where this question is coming from. So maybe you could, I mean, to the extent that we have the information, you could share that with us. Yeah.
Well, it is true that the right to information really is a right which strengthens the democratic framework in any country. So what we have seen is that most democracies, most countries which refer to themselves as democracies, do have right to information laws now. There are nearly 150 countries across the globe that have the right to have a right to information law or a variant of it. Like I mentioned, not all of them are being used very vibrantly. In India, citizens, people have understood the power of information and are using the law very vibrantly. But it is very much there in countries across the world, the countries that call themselves a democracy, because let us understand that what is a democracy? How is it set apart from any other form of government? The most important feature of a democracy is that I can question the government. I can question those in power, which I probably can't do in an autocracy or in a dictatorship. So the right to information is the right to question, because it really gives each person on the street the right to come forward and hold the government accountable. So it's a very fundamental democratic right, and it is being exercised in countries across the world which are calling themselves democracies. Kerala, as far as Kerala is concerned, of course, the right to information law is very much there in Kerala. It's a national law for us, so Kerala is covered. It's being used very vibrantly in Kerala. And like in other parts of the country and other states of the country, there are problems there as well. So we do see that the same kind of issues that plague the right to information implementation of the RTI law in Rajasthan, in Madhya Pradesh, in Karnataka also exist in Kerala. So we have cases going up to the information commissions. The commissioners, there are not always timely appointments made to the information commissions in all these states, including Kerala. Sometimes appointments that are made to the commissions, people challenge them in the court of law because they don't find that the right sorts of people have been appointed as information commissioners. But I think that what is important is that given how the education levels, the literacy levels in the state, the use of the law is very vibrant in Kerala, and people are using it. Even if governments don't want to share information, like they don't want to share in other states of the country as well, people are persisting and they continue to demand and ensure that they get their right to information.
Very encouraging. There's another interesting question here. How do you see the future of RTI in the light of increasing physical attacks on activists and the stonewalling tactics adopted by the government? Here, do you think that we should have, of course, it's the wrong time to ask this question, but do you think we should have more provisions to protect whistleblowers? One question. Second, but actually, are these people misusing the RTI Act? That's another question here. That there are vested interests who are misusing the RTI by selective individuals.
So let me go in the reverse order, Vikram, if you allow me. Let me take on the question of the misuse of the RTI Act first. First of all, the right to information is a law, is a tool. It's a tool to access information. Like any other tool, there might be people who might want to file many applications to the same person with the purpose sometimes of also troubling the other person. I'm not saying that there is no possibility of misuse of a tool. However, what needs to be understood, and this is very important, is that how on the whole has the law been used. There has been many concerns that have been raised about frivolous and vexatious RTI applications being filed by people. And in fact, even the previous Prime Minister brought it up in various times and said that the RTI law is being misused, frivolous and vexatious RTI applications are filed. Many ministers in this government have gone on to say that. We filed RTI applications to the government saying that, can you please share with us what is the percentage or what is the data on which these statements rely? And the governments have come back and said, we don't have any data to back these statements. So we then decided to undertake an assessment to see how many applications in the country are being filed, which can be called frivolous or vexatious. Now, the first problem is, how do you define frivolous or vexatious? Because when you say that something is vexatious, it angers somebody. If I expose corruption by someone or wrongdoing by someone, I'm sure they'd be very angry and vexed. So, should we not file those RTI applications then that expose corruption and wrongdoing? The other is frivolous. Somebody said that, people come to us and ask for information about 200 rupees, 300 rupees. It wastes so much of government time. But if you look at people who get old age pensions from the central government of 200 rupees, they survive on that sort of money. So when an old woman asks for information about her old age pension, is that frivolous information? Because for her, it would be a matter of life and death. So it's impossible to define what is frivolous or vexatious, but we took the most, liberal interpretation of frivolous and vexatious, and we looked at randomly selected 20,000 RTI applications across the country. We found less than 1% could be termed frivolous or vexatious. Most of the RTI applications were actually asking for basic information. There was a woman who said that I had applied for the job of an Anganwadi worker 7 years ago. I still have not got information on whether I was accepted or rejected. Can you please tell me, give me my records so that I know? There was an old couple which said that after retirement, they had invested in a DDA plot, and they said that we were told that we had been allotted the house, but we have not got the allotment letter for the past 12 years. We are still waiting. Can we please get that allotment letter? So these are the kind of applications that were there, and which showed how in perspective, if we look at any kind of misuse that is talked about, that, it's really negligible as compared to the way in which the RTI law is being used in the country to hold the government accountable for delivery of basic rights and entitlements. The other thing, of course, is that we very often say that if governments are worried about the time that PIOs have to spend in giving information, the best way to tackle that is to put information proactively under Section 4 in the public domain. If the government doesn't have anything to hide, they should just put information out. It will prevent people from filing RTI applications, because then they will just be able to go to the nearest board or to the website and access that information. They won't have to spend their own time filing those RTI applications as well. So the law is very clear. It only allows us to access information that exists, records that exist. As citizens, we can't demand that any new record be generated. So the question of misuse, therefore, doesn't really arise, because what can I as a citizen use the information RTI for? It is just to access information that exists in government records. And if that information shows corruption or wrongdoing, and somebody then exposes it or uses it to expose somebody who's indulging in wrongdoing or corruption, that's not really misuse of the law. That's actually using it for a purpose that it's meant to ensure accountability. The other issue of whistleblower protection. One of the things that RTI users have been at the forefront of is to demand a strong Whistleblowers Protection Act. And the law was passed in 2014 along with the Lokpal law. Unfortunately, like I said, although the expectation was that the current government will immediately operationalize the Whistleblowers Protection Act, till date, the rules have not been framed. So it's been nearly 8 years since the law was passed, but nobody can use it because the government has not framed rules to operationalize the Whistleblowers Protection Act. Under the law, people who expose corruption and wrongdoing, like RTI users, can get protection from the police and other agencies if they are being attacked, if they are being threatened, because the law is only on the statute books and it is not being implemented. It is not being useful for people who expose corruption. As far as the future of the RTI Act is concerned, I am of the firm belief that the law came as a result of a demand by people. It was demanded by people. It has been used by people, and it is being protected by people because they understand the power of information. So I don't think that any regime will be able to get rid of the right to information law, even if they want to. But yes, if, like I said, there are attacks on the transparency regime, on the RTI law, and citizens will have to be vigilant. They will have to be active in protecting the law and making sure that there is pressure on the government to not dilute this right in any way.
There's an interesting question here on Artha Satya. How does one ensure that the information provided in response to an RTI application is factual and not manipulated? Actually, though this is not a right example, but the government has said in the context of Pegasus that the Ministry of Defense has not paid any amount. They did not say whether the Ministry of Panchayat Raj has paid any amount. So I would like to know, how do you say that it's factual and not manipulated?
Right. Now, there are two sorts of things, and I'd like to sort of separate them. Typically, when information is obtained under the right to information law, people have the power to inspect documents as well. So there are several kinds of ways in which we are given the right to information. One is that I can ask the government for certified copies of documents. That is possible for me to obtain as a citizen. The second is that I can file for inspection of documents. So very often, when we suspect that information might not be accurate, we also ask for inspection of the files so that we can actually compare what we are getting to what exists in the files. And that is something that we often encourage people to do if they suspect that information that is being provided to them is not accurate or might have been tampered with. Now, Vikram, as far as your question is concerned, that's a far more fundamental question. That is a question of mindset. That is a question of intent. So when in Parliament, the government says we don't have any information about deaths due to oxygen shortage in the country, that there were no deaths that happened due to oxygen shortage during COVID pandemic. When the government says we have no data on unemployment, when the government says that in Pegasus, no money was spent by a certain ministry. Now, those are far more difficult to prove because there, finally one would have to go to the adjudicators, whether it is the information commissions or finally it is courts of law, the judiciary, where some of these matters would have to be settled. Because how can a government, a responsible democratic government, make these claims and say we don't have data? Because this is the final and the most crucial kind of attack on a transparency information regime, when the government says, I don't have information. So, I mean, what good is my right to information if the government starts saying that I don't maintain information? So this is the ultimate subversion of people's right to information, which has to be taken up. It has to be resolved, and governments have to be shown and told that this cannot be tolerated. So I think that as far as government data and records are concerned, the veracity of these documents that are shared can be checked easily through inspection and other means. But where governments just put up their hands and say we don't have any data, that's something that we probably need to take up public campaigns on and pressurize the government to make sure that they can't get away with such things.
Thank you, Anjali. You've spoken with so much passion and clarity. Each point, many of our viewers have already recorded their appreciation on the YouTube questions. Thanks a lot. Perhaps one last question from Mr. Sharma, who asks whether the RTI can be used to get information on voter misinformation, manipulation, as for example carried out by Cambridge Analytica or Facebook. Is that really possible, or since those are really issues relating to private organizations, there is little possibility of using the RTI?
Well, Ram, I think this is an important question, and it kind of touches upon many issues. So I'll just try and address it in a few of these, in a few sentences. First of all, whether data that is held by private companies can be accessed under the Right to Information law. Yes, it can be. In fact, the Indian RTI law very clearly, while defining information, says that this is information that is not just held by the government, but is held by any other body, which can be accessed, information that can be accessed by the government under any other law for the time being in force, can be accessed by citizens under the RTI law. So let me give you an example. Supposing there is a factory that is creating pollution somewhere, I might not be able to file an RTI application directly to that organization because it's a private body, but because under environment laws they would have to give information to the Environment Ministry, I can access information about them through that ministry. So information can be accessed about private bodies and their functioning. So when we talk about voting in this particular case, if we can identify the individual organizations, it should be possible to query them as well, even if they're private bodies. The second thing is that I want to say that when we talk about voting being subverted and lists being subverted, there are different aspects to this. One very important aspect is electoral funding, political party funding. And, 6 national political parties were declared public authorities under the RTI law by the Central Information Commission. And it was done basically with this purpose, that people could ask for information from them. Who are the candidates they're selecting, how they're selecting those candidates, where are they getting the funds, and how are they deploying the funds that they are getting. Unfortunately, in an act of what we can only call uncivil disobedience, all these political parties are sitting in violation of the CIC direction and are not appointing public information officers to give information to citizens. So there is a huge problem, like Vikram said, the law is just 16 years old. It is a relatively new law. It needs to be pushed, the boundaries of it. Implementation is not perfect, but we need to keep at it and make sure that political parties and different organizations are made accountable and transparent under these under this legislation. And finally, in terms of voter information, the Election Commission of India and other bodies which hold information, relevant information, can be queried using the RTI law in terms of voter lists, in terms of ensuring and checking that the voter lists are in order. People have been using the RTI law to monitor and to hold the system accountable. I hope it kind of answers the question.
I think many compliments on the way you have given your elaborate answers of each one of those questions. I really thank you, Anjali, for being with us this morning. Unfortunately, this cannot go on forever, but I'm sure that we have many more questions to ask. And I can only say that Manthan will be with you, and I hope you stay with us, Manthan, in building a stronger and a vibrant democracy. Thank you.
Thank you, Anjali.
Absolutely.
Thank you very, very
Thank
much
you.
for giving us so much time. Very excellent talk.
Friends, next week on February 20th, we have a speech by Justice Madan Lokur on the executive, the courts, and the hate speech, things we can do. It promises to be a very interesting topical point. And I invite you all next Sunday at 10:30. Till that time, thank you very much, Anjali, and thank you everyone in Manthan for staying with us this morning.
Thank you very much. Thank you, Vikram. Thank you, Ram, and
Thank you,
everyone at
Anjali.
Manthan.
Yeah.